Call the meeting to order. Welcome to meeting number 60 of House Commons Standing Committee on Finance. Pursuant to Standing Order 1082, the committee is meeting to study the coming into force of Bill C-208, an act to amend the Income Tax Act, transfer a small business or family firm or fishing corporation. We went through the rules for this room this morning on the pandemic and social distancing and stuff, so we don't need to go through that again. So we'll start with the witnesses. I see Miss Aiken, you've been working steadily. We've had you on screen here, and you're getting a lot of work done while you're waiting for us to come on. So welcome, Miss Aiken, Executive Director and Senior General Counsel, Legal Services Law Branch. And then we have Mr. Jovanovic, Associate Assistant Deputy Minister, Tax Policy Branch. And Trevor McGowan, Director General, Tax Legislation Division, Tax Policy Branch. And Trevor is no stranger to this committee. I think he spent pretty near as many hours as some of us have. Right, Ed? So with that, and I don't believe there's an opening statement. If there is, raise your hand or yell. Otherwise, we'll start with questions, 6-minute rounds. Will be Mr. Fast, Ms. Zerowitz, Mr. St. Marie, and Ms. Matheson. And so, Mr. Fast, you're first on deck. Welcome. Go ahead.
Well, thank you, Mr. Chair. And my questions will be to Mr. McGowan. Trevor, you've been at parliamentary committees many times before, as the chair has suggested, so you know the drill. And when a private member's legislation comes before a committee, we generally have a robust discussion about the legislation, and the government, through its MPs, has the ability to bring forward amendments that would fix loopholes or deficiencies in those bills. Now, Mr. McGowan, you were present at committee as a witness as Bill C-208 was being discussed, correct?
That is correct.
All right. Your recent press release, a finance department's press release dated July 19th, highlights 4 specific loopholes that you feel should be fixed in C-208. Now, my question to you is, when you appeared before committee as a witness to discuss this bill, did you or any of your officials recommend amendments that would have addressed the shortcomings that Bill C-208 had, and specific wording for those amendments?
As was stated, my colleague Sean Porter and I appeared before the House Finance Committee and the Senate Committee on Agriculture to discuss Bill C-208 and provide comments on the technical aspects of the bill. During that time, we provided technical commentary and analysis in respect of the bill, but our involvement was limited to that. We weren't suggesting amendments, but certainly we did raise some of the concerns that are alluded to or mentioned in the July 19th press release.
So what was the purpose of you appearing before committee if there was no process by which finance could inform the committee and provide it with the assistance and the wording for amendments that could have fixed the so-called loopholes that you've identified after the fact?
As I understood the purpose for my appearance before the House Finance Committee, it was to provide information and analysis on the technical aspects of the bill so that members of the committee had the appropriate information to make decisions.
Okay, so after royal assent, somebody in government, maybe in finance, maybe in the Prime Minister's office, made the decision to announce that Bill C-208 would not be applied. In other words, it wouldn't be implemented right away, correct?
Just to be technical in the terminology, when Bill C-208 received royal assent, it produced its effect. It became part of law, and it amended the Income Tax Act. So on June 29th, the date of royal assent, Bill C-208 amended the income tax, and as of that date, the provisions that it amended were part of Canadian law. In terms of, and so that's the date on which it came into law, and that's, I mean, that's just a fact and not something that could be changed.
Well, let me say this. I'm so glad that you're now acknowledging that Bill C-208 became law on June the 29th. It's something that was not reflected in your June 30th press release. So I want to know, who was it in your department or who was it in government who made the decision not to respect Bill C-208 and issue the press release, which led to the confusion and, quite frankly, bewilderment of the small business community in Canada?
I suppose there are two things to discuss there. The first relates to the decision-making process in terms of the press release, and in that the department follows the regular approval process that we use for all of our public communications projects in alignment with the requirements of the federal communications policy. But then in terms of the substantive portion of the question, as I said, on June 29th, Bill C-208 produced its effect and amended the Income Tax Act. And the government's announcement on June 30th was that the government proposes to introduce legislation providing that the amendments would apply only as of January 1st, 2022. So it's perhaps a technical point, but that the June 30th amendment would amend the Income Tax Act, which had been amended by Bill C-30 ahead of time, but the government produced or was announcing its intention to table legislation to provide a Jan 1, 2022
Trevor,
application
really,
date.
I mean, that is a recharacterization of what has happened. The June 30th press release made it very clear that the government was going to withhold implementation of Bill C-208 until it had a chance to amend it. In that, it was moving in a way that effectively defied the will of Parliament. So my question, which you didn't answer, is who in finance or who in government actually made the decision that was then reflected in the press release that was issued on June the 30th?
Well, as I said, getting back to the
Answer the question.
approval process for the press release, it followed the normal federal communications policy, which involved a number of groups within the Department of Finance or branches working on the press release.
I'm not asking about process. I'm asking who made the final decision.
I think Mr. Fast give Mr. McGowan the opportunity and the courtesy time to answer the
With respect,
the
Mr.
question.
Chair, you know what he's doing. He's not answering the question. I've asked who, and he will not provide me with that answer. All we want to know is who was the decision maker that made the decision to issue the press release that reflected the government's decision not to respect the will of Parliament.
And
Point of order.
And you've been in government, and it isn't in these matters. It isn't usually a single individual.
Right.
Mr. McGowan, if you could answer as specifically as you could, please.
Thank you. I just wanted to be clear that in terms of the press release that we'll be clear on specifically what it did. But in terms of who made the decision, the press release stated that the government proposes to introduce legislation that's a reference to the elected government of Canada, and its intention to table a bill, and so that is a proposal of the government of Canada and not.
Let me stop you right there.
We're out of time, but
Yeah.
I will give you, and I'll give others
Mr.
time as
Chair.
well. That'll be the last
Who in
question.
the elected government made the decision to issue this release, or to instruct your department to issue this release, which has led to all of this confusion?
Mr. McGowan, I believe you answered that question, but go
Oh, he
ahead. I'll
hasn't
give you
answered
another
the question.
stab at it.
Who in the elected government made that decision?
That's the last question, Mr. Fast.
God, you guys are awful.
Okay.
Point of order.
No,
I have a point of order from Mr.
Sorry.
Garrettson. Sorry, Mr. McGowan.
With all due respect, Mr. Chair, Mr. Fast just said off the cuff, you guys are awful. Can he explain who he's referring to? Is it the departmental officials that are before us? Because if so, he owes an apology for that comment.
Okay, I'm going to leave it at that. You've made your point. Mr. McGowan, do you want to say a couple of last words in this round, and then we'll move on to Ms. Zerowitz?
Well, as I said, it was an announcement of the government's proposal. It was, as I was starting with the approval process, of course, the Department of Finance officials provide advice to the minister, and then we implement government's decisions. And so I was simply trying to highlight the fact that this was a government proposal to table a bill in Parliament that would affect the application date of the amendments included in Bill C-208.
Okay, thank you. It's not, what's your point of order?
Order, Mr. Chair.
I hear you.
My comment addressing you guys are awful was not addressed at our civil servants, and it certainly wasn't addressed to Mr. McGowan. It was addressed to my Liberal friends across the table from us who were heckling and guffawing about us asking very significant questions of Mr. McGowan as it relates to Bill C-208.
We'll leave it at that on the cross the table. We're more than 2 sword lengths apart here, so we're okay at the moment. So we will go to Ms. Zerowitz, and because we don't have the witnesses at the table here, Mr. McGowan, if some of your other colleagues want to come in and assist on an answer or give an answer, they'll have to yell. I guess it's the only way that I can bring them in, or you can direct that way. Ms. Zerowitz, 6 minutes. We could, or a little better.
Thank you so much, Mr. Chair, and I want to thank the 3 officials from our Department of Finance for being here today. I really appreciate you being here to answer our questions. I want to just start off by clarifying a couple of things because I think it's important to have this on the record. Could you please explain the difference between coming into force and application or coming into effect?
Thank you for the question. I'd be happy to do so. It is a somewhat arcane thing that doesn't come up much, but it is critically important in the preparation of tax amendments. So as I said initially, for example, the amendments in Bill C-208 came into force on the date they received royal assent. That is to say that the bill amended the Income Tax Act on that date. But that doesn't necessarily mean that their application to any particular transaction is going to be clear. And in particular, when we're putting together income tax amendments, it's important, and we typically do set out specific application dates. So for example, one reading of coming into force date in the middle of a taxation year is that it applies to transactions that occur on or after the date of royal assent. Another reading of the measure is that, well, because a taxpayer's liability for tax crystallizes at the end of the taxation year when it is computed, that it's the law at the end of the taxation year that is relevant for the purposes of computing tax. And so a coming into force date that simply appears in the Act on, say, June 29th, it is ambiguous in that it's not clear if it applies in respect to transactions that occur on or after that particular date, or for the 2021 taxation year. And that's the reason that we typically, in drafting income tax amendments, set out specifically when an amendment applies for. So it could apply, for example, in respect to transactions that occur on or after a particular date. It could apply as of a particular taxation year, or there are a number of different formulations. But
Thank you. Sorry,
Addressing that and
it's
providing
past
clarity
2
is
minutes
why we
now,
do
so
it.
I have to get to a few more questions,
Sorry.
but I appreciate your response. I'll get to very quickly in terms of what was the intention behind the June 30th news release. Was it to change the coming into force date? So the date that C208 came into law?
As I said earlier, and I apologize, I'll try to be more brief, but as I said, the coming in force of Bill C-208 was a factual matter. It did amend the Income Tax Act on June 29th. That's just when it produced its effect. What the proposed amendment would do, and of course it would have to be included in a bill, as stated, the government proposed it to introduce legislation, and that bill would need to receive royal assent. But if passed, it would have the effect of providing that the amendments that had been made as a result of C-208 would not or would apply as of January 1, 2022.
Okay, so it would go into effect, but the amendments would be applied after January 1st, 2022, according to the news release.
Yes, it's quite common when making income tax amendments that they apply as of a future date. And so a bill, like, for example, Bill C-30, a recent budget bill, might have a number of amendments that that even though it also got royal assent on June 29th, they might not start to apply until a later taxation year or a later date in the future in order to give taxpayers and the tax administration time to respond.
Okay, so my next question is, if I own a family farm right now, and I decide I'm going to sell it to my daughter, and so that transaction happens over the next month, what actually happens? So does it apply? Does C-208 apply, or whatever is passed or introduced as of November 1st? Is it retroactive to sales after June 29th?
Yesterday's or July 19th's announcement provided that the Bill C-208 amendments currently apply, and any new amendments put forward by the government, which, as we've discussed, would need to be included in a bill and passed through Parliament, would not apply before November 1st, 2021.
Okay, so sorry. If I sold a farm to my daughter, right now, would Bill C-208 apply, including whatever amendments we actually make for the income tax provisions after November that we introduce after November 1st?
The relevant provisions of the Income Tax Act, as amended by Bill C-208, would apply to a transaction undertaken today, and that's based on yesterday's press release. Mm-hmm. And the government announced that any new amendments would not apply before November 2021. So any transaction undertaken from now until the end of October,
okay.
The government announced that whatever new conditions it might include in a bill that again would need to be passed by Parliament would not apply.
Okay, I'm actually clear on that. So okay, thank you. The other question I have is, as you know, Mr. McGowan, this has been the bill that finally passed. It's actually the third time that's actually passed, that's been introduced into the House of Commons. It's been probably around 10 years that it's been sort of discussed, I'm sure, within the Finance Department. We know that U.S. and Quebec already have a model that works. Why is it taking us so long to address the loopholes that we have identified?
Well, I think the answer to that is that it is a complex issue with a number of competing factors. I think that, as I said in my earlier committee appearance, a lot of people have an intuitive sense of what it means to transfer a business to the next generation, but it is a difficult thing to legislate with precision, so that all of the genuine intergenerational transfers are accommodated under the rules, but more contrived or artificial transactions are not. And so it's just it is a complex thing. But
Thank you.
Did you want to add more there, Trevor?
No, thank you.
Okay. All right, we'll go to Mr. St. Marie, followed by Ms. Matheson.
Oui, merci, Monsieur.
Thank you, Mr. Chairman. First off, welcome to the witnesses. Thank you for being here. Before I start asking my questions, I'd like to mention how important the work of all the senior officials, all the department's staff has done during the pandemic. We know at the committee here we have heard from witnesses from the department that have done extraordinary work to save our economy. So I really tip my hat to you, and I really thank you once again for everything you've done. Now, my questions are for Mr. McGowan. Given yesterday's press release, given what Ms. Bendayan said a little earlier, in my mind, everything was clear. And then when you answered Mr. McGowan, in fact, when you were specifying things with Ms. Jerkowitz, I became completely confused. So there was royal assent in June, and now, again, I want to ask you this question. Since C208 received royal assent, a family that sells their farm or another company to their children will do so based on what's been passed in C208. Is that correct?
That is correct. Right now, it is absolutely correct. And what I was saying in respect of the government's July 19th announcement was that while the government has announced its intention to provide additional conditions that may need to be met at the end of a consultation process, those new conditions would not apply before November 2021. So right now, the rules in the Income Tax Act that were amended by Bill C-208 are the law and can be relied upon.
OK, merci. Donc, ça, c'est...
Okay, thank you. In fact, that's what Madame Bissonnette, from the Fédération des Agriculteurs, wanted us to ask this question. So thank you. My colleague Julie also wanted an answer to that. Another answer that you gave to Mr. Jerkowitz concerned me a bit, and I think you just repeated it in your answer to my question. So since yesterday's press release, you were saying things have applied in this way. So what the former representatives of the House told us this morning and what the legal experts told us this morning is that it has to be the case, regardless of any press release, as of the time that the royal assent happened. Yesterday's press release specified things, but since royal assent of C-208, bills could be sold in a context of intergenerational transfer in a normal way. Is that correct?
If I understand the question correctly, right now the rules as enacted by Bill C-208 apply and can be relied upon. It is the law of the land.
Très bien. Merci beaucoup.
Very well. Thank you very much. Now, on a second point, it has to do with the amendments. As you stated, the government announced in yesterday's press release an intent to bring forward some amendments to Bill C-208. So this would be in the form of a new bill that would amend the Act by maintaining the spirit of C-208. What concerns me, or what I'm surprised by, is what we heard this morning is that first reading of the bill was on February 19th, 2020. So 527 days is what it took to go from first reading to royal assent. 527 days. And as Mr. Dufresne said this morning, at every stage, the government could have submitted amendments as it is stating it wants to do in a future bill. Now, given your answers to Mr. Fast earlier on, I gather that, let's say, during the committee study of C208, the government did not ask you, the Department of Finance, that is, to prepare amendments to C208 so as to close these potential tax loopholes. Is that correct?
As part of our committee appearance, I guess this spring, discussing Bill C-208, department officials were present to help explain the technical aspects of the bill, and I would need to defer to the honorable chair of the committee in terms of the rules. I'm not even aware if department officials could table amendments to a bill at a committee hearing, or whether that would have to be done by a
Je
member.
crois que je m'étais mal.
Sorry, perhaps Mr. McGowan, I was misunderstood here. So it's not up to officials to bring forward amendments. It would be the responsibility of government representatives to bring forward amendments that would address the concerns that you raised with the government regarding this bill. So my question is the following. Did the government ask you to prepare amendments to address some of these breaches or some of the issues that exist in C-208 or could have existed and were raised during the committee study? Did the government ask you to prepare those amendments?
In connection with my last hearing, I don't want to be I want to answer the questions as fully as possible, but I'm not sure that starts to get pretty close to describing our advice and internal instructions from the government, and I would defer to my colleague Jennifer's views on those about whether that's something that that can be appropriately answered.
Ms. Aiken, if you want to come in there, I mean, I think it is pretty clear. The officials would advise government on what amendments should be made, and it would have to come forward at that stage as a government amendment or from a member of the committee. I think that's the procedure. But Ms. Aiken, do you want to come in?
Mr. Chair, I think you've expressed it very well, and in terms of what we are at liberty or not to say, I agree with Mr. McGowan that we want to say everything we possibly can to be helpful. That's what we're here for. But we're not at liberty to talk specifically about questions of advice. But okay. I think, Mr. Chair, you explained the process.
I think that's fine. We understand that there's the political side and there's your side. Okay, we will go to, thank you all on that round. We'll go to Ms. Matheson, who for 6 minutes will be followed by Mr. Kelly for 5.
Thank you, Mr. Chair. I kind of want to back things up a little bit, sort of go back into the history of this bill. And as Ms. Zerowitz had mentioned, there were several reiterations of that. Of course, I refer to the NDP version of this bill, C-274, which was actually voted against by this government, and we were told that it would not pass. However, then after the election, in Budget 2019, it was indicated that something similar, a piece of legislation would come forward to help farmers, small businesses, fishing businesses. And in fact, it was also in the minister's mandate letter from the Prime Minister. So can you indicate to this committee what plans and what directions were received from government, from the minister as directed from the PMO to put forward this legislation? And I think building upon what my colleague, Mr. Saint-Marie, was discussing, having all of that time, having those plans in place, why a lot of the amendments weren't prepared for legislation that came forward under Bill C-208.
Mr. McGowan or Ms. Aiken?
Whoever's
We may be
allowed to
crossing.
answer.
Pardon?
Maybe I can
They're
take
okay.
this one. Yeah.
Go ahead.
Thank you very much. Thank you very much for your question. Mr. Chair, I think the question goes somewhat in the same direction as the previous one. It seems to be related to the nature of the advice we would have provided to the government. I mean, I don't think that it would be appropriate for us to go into any detail as to the advice that was provided, or whether the advice, what they were covering. I mean, I would just say our role as tax policy officials in a department is to make sure that on an ongoing basis, the department and the government has all it needs to make decisions, and our role is to try to provide advice.
I certainly, and I appreciate that. I understand that, and I understand what the response was given previously. However, I would argue that this is actually the other way, right? This is direction from the government, coming through the minister, coming through a mandate letter, coming through the budget 2019, and what you were determined or told to put forward in terms of ongoing or upcoming legislation that the government had in plans. So it would be going the other way.
I think I would maintain my answer. This is effectively would be for me to say, for instance, what measure has been considered by cabinet, which would become potentially cabinet confidence. I don't think that I'm at liberty to say that following the commitment made in 2019 or in the mandate letter, whether indeed a specific proposal have been put forward and discussed with the government. I'm not sure I'm at liberty.
Yeah, I think it's just the other way around, Ms. Maths, on that. I think Mr. Jovanovic is correct on that.
Okay, fair enough. Could we then discuss those specific amendments that are being brought forward and that were in the newly released press release, where clarification was provided? It's my understanding that the government said parents can already sell to their children on a tax-free basis using a lifetime capital gains exemption. Is that before this C208 is brought forward? Is that true, or is that false? I believe it was in a speech actually from Mr. Garrison when he was discussing C208.
That's correct. The amendments relating to Bill C208 only apply where an individual sells shares to a corporation owned by their child or grandchild. And on a direct sale of shares from a parent to their child, then the anti-avoidance rule in 84.1 would not apply to cause there to be a dividend. And in fact, assuming all the conditions are met, the lifetime capital gains exemption can apply to eliminate any tax or up to the lifetime capital gains exemption limit anyway on any gains.
Okay, and the requirement, one of the requirements or the amendments being made was that enough time and a specific timeline be put forward for that transition to ensure that it was a legitimate idea of a legitimate sales to a child. Within that 208 legislation, it also says though that the person receiving the gift of this farm or small business would have to own it for 5 years. Why is that not good enough within the C208 legislation?
The issue with that is there are a few technical issues. The first of all is that the amendments enacted by Bill C208 place the 5-year or 60-month holding period on the corporation that purchases the shares from the parent and not the child. There's actually no requirement in Bill C208 that the child maintain any sort of share ownership in the business. It's the corporation that purchased it, and the child could in fact sell the shares of within the 5-year window.
Last question, Ms. Matheson.
Okay. Well, it's confusing where these amendments they seem to do what's already being done, and if not, it's that there's a belief that ultimately these families and these children are trying to undermine the government, take advantage of tax loopholes. I find it interesting that the government now is so interested in closing tax loopholes where they hadn't before. However, it seems that a lot of this was already done, and these amendments may be redundant.
Any thoughts on that, Mr. McGowan?
Well, as I said, the 5-year holding period imposed by the rules enacted by Bill C-208 applies to the purchasing corporation and not the child. And so, I mean, the child could sell within that period. So it does not actually provide an effective rule that would require the child to have an indirect share or indirectly hold shares for 5 years. And I should say as well that the government's news release that went out yesterday did not provide specific amendments that would be made. Rather, it announced a general set of issues that would be taken into consideration in the development of draft legislative proposals. Those included, the transfer of legal and factual ownership of the corporation to the child, the extent to which the involvement of the business is transferred from the parent to the child, and some other measures like that. So it was more of a description of the types of issues that would be considered in the development of draft legislation than a specific set of draft legislative proposals that was announced yesterday. The draft legislative proposals, I think, would be released at an early opportunity and subject to comment, and then final draft legislative proposals would be released later on.
Okay, thank you all. Mr. Kelly will go to 5-minute rounds, and you're up.
Okay, thank you.
Followed by Mr. Fragascatis.
Okay, thank you, Mr. Chair. And to continue with Mr. McGowan, Mr. Fast asked you many times in his opening statement who authorized the announcement, or who decided to put that announcement out. The first several times you didn't answer the question by merely referring to regular process. On the final time, you spoke of members of the elected government as making the decision on this announcement. By that, I presume you mean the Prime Minister, other members of his cabinet, or the members of their offices that serve them. Can you tell the committee who in the elected government decided to put out the first notice on June 30th to announce that you were not implementing a law passed by Parliament?
Well,
Go ahead, Mr. McGowan.
The opportunity. Thank you for the opportunity to continue that. I apologize if my answers were a bit long-winded in getting to the point. Your question was who decided to announce that the amendments would apply as of June 30th. As I said, it was an announcement of the Government of Canada. It's something that department officials briefed on. The minister made her decision, and it was implemented. So it was an announcement.
So did I just hear you correctly that it was the minister that decided that you would delay implementation of a law passed by Parliament? It was the Minister of Finance?
Well, you see, that's part of the difficulty in answering the question, because the announcement was not to delay implementation of a bill passed by Finance. Rather, it was to table a bill in Parliament that would, if passed by Parliament and receive royal assent, provide that amendments or rules in the Income Tax Act that have been implemented through Bill C-208 apply starting as of January 1, 2022. Of course, as we discussed on June 29th, the amendments to the income tax were made. There was nothing that could be delayed on that front. And the as I've said before, including before the Senate committee on
On the
agriculture, the CRA wouldn't apply the law as enacted because it is the law of the land,
okay, so
barring some future parliament.
Mere
action.
hours before this committee meeting was scheduled to begin, where parliamentarians could demand answers as to why this announcement of June 30th went out, there was a clarification to backpedal this announcement. But again, the question that I really wanted clarity around is whose idea in the first place was it to delay? And the June 30th announcement is pretty clear. It talks about the absence of an application date and talks about implementing on January 1st following amendments. So was it the minister? You said the minister in your last answer to me. Can you clarify that it was you meant the Minister of Finance?
I see Neo's joined in.
Yes. If I may, thank you, Mr. Chair. So I think I would like to maybe go back to the nature of the announcement to understand the process here. I mean, I think it's instrumental to understanding the decision process, because what happened in this instance is no different than what happened in all other instances where the elected government announced that they intend to table legislation to modify, if Parliament approves, to modify existing legislation. And I think, just to be clear, this is exactly what happened here with the announcement on June 30th. It's no different. And the process we follow is typically we provide advice and options to the government. It's frank and impartial advice, and the government deliberate at a political level. They have their own set of considerations. We don't necessarily participate in these discussions, and they make a decision. And we have to implement that. As part of the implementation, we continue to provide advice to make sure.
Okay, I'm sorry. I'm going to have to interrupt.
Well, I'll give you time. We'll go over a little time. We're going to have lots of time in this 2-hour panel, but I want Mr. Jovanovic to have time to respond to the question.
Thank you, Mr. Chair. In this instance, what we want to ensure is when a decision is made to release that announcement, that we make sure that the announcement reflects the decision of the government, that it is technically accurate, and that it is respectful of the role of Canadian institutions, including Parliament. And that is our primary role, that to the extent possible, we hope we do properly. And so when it comes to determine who made the decision, it's unfortunate, but we really cannot provide more answer to that.
Well, we've had about 10 minutes now of question from my conservative opposition colleagues, and in this time we've circled it down to a minister seems to have made the decision. We don't know, we can't confirm yet which one, but that was the question, whether it was the Minister of Finance. But further to that, I take you to the June 30th announcement. This announcement speaks of the bill having received royal assent, but does not have an application date, and then goes on to talk about amending it and starting on January 1st. How? I mean, but I don't really even want to go down that path any further about what the amendments that you may propose might be. We'd like to know who made the decision on that press announcement. Which minister?
I actually think, in fairness, the witnesses, Mr. Kelly, have said all they can on that subject. Any decision is by Executive Council as a whole, and whatever specific minister helped make the decision, it's a matter of cabinet decision.
Is that
It's a matter of cabinet made the decision?
Well, it's Executive Council at the end of the day.
Okay, so this was a decision of cabinet, not of the department.
So I don't know if you want to add anything further on there, Mr. Jovanovic?
So this was a decision of Executive Council.
Well,
no, Mr. Chair, I think I'm fine.
Okay. All right, we'll go to Mr. Fragaskatis.
Thank you.
Pat?
Thank you, Chair, and thank you to
Chair,
officials. Mr. Chair, I'll be splitting with Mr. Gerritsen.
We have lots of time for everybody to get on if you don't want to split, but go ahead.
I'm
okay,
sure
you can split this time and come back
there,
later.
there still may be an opportunity to split with Mr. Gerritsen.
You can
and he
split.
can have his turn too. But
You can split and then come back and split again if you like.
for
Pat's gonna
reasons
chair
that
for a
I'm
minute.
about
Go ahead,
to put on record, Mr. Chair, I think you'll see why there's a need to split time. If I could, I suppose this could go to any official, but I'll begin with Mr. McGowan. Mr. McGowan, did you have an opportunity to hear the testimony this morning offered by Mr. Dufresne, who serves as you know, Parliament's chief legal counsel and is the law clerk for Parliament?
Unfortunately, I was in meetings this morning, but I did have a summary of that prepared for me by some of my colleagues.
Okay, so as part of that summary, perhaps you would have seen that Mr. Dufresne made clear when I asked him, and I think this question was put to him by others as well, that yesterday's press release clarifies the matter. If there was clarity needed, yesterday's press release makes things absolutely crystal clear. That is to say that by recognizing, as the government did yesterday, C-208 in the way that it did, the matter is a matter of law, that it came into being through royal assent. And while my friends in the opposition can point to one press release, interestingly enough, they're pointing to one press release, but not yesterday's. They're pointing to one released a few weeks ago. We've provided clarity here on the matter today through a meeting called by the chair, and to his credit, I think it was a good idea to call the meeting. There's no air in this balloon, colleagues. I don't understand. We can go around and offer hypotheticals about what might be, what could be, what happens, months from now, years from now. That's all hypothetical. We have to focus on the concrete, and I think we have, through the statement that was offered yesterday through the Department of Finance, a very clear understanding now that the government recognizes that Bill C-208 is a matter of law. You offered, Mr. McGowan, a explanation, not an explanation, but an answer when prompted. I'm not sure who put the question. Maybe it was Mr. Fast. But I remember the statement. It was, you said that C-208 is now the law of the land. Is that accurate? Can we understand it that way?
Yes, it has amended the Income Tax Act, and it produced its effect.
So,
and it is, the amendments it introduced are now part of the law of Canada.
Okay, well, I'm satisfied, and as I said before, I wanted that understanding because I did vote for this bill. I think it was worth supporting, and we can go around and colleagues will take their time to ask questions that they think need to be put on record. I won't, question their privilege to do so. But we really are spinning our tires. I think the matter's been resolved, but I'll turn to Mr. Gerritsen to fill out the rest of the time.
Given what the chair had said, perhaps I think I'm the next person on our side anyways, so I don't think there was that much time left, was there?
A couple of minutes.
I'm going to challenge the chair on that, I think.
If you would like to, we can move on to the next speaker. If you'd like to, if you have nothing to add.
No, I'll just wait, unless another colleague would like to.
Okay. Thank you then. And next on our list, I'm sorry, Mr. St. Marie is next for 5 minutes.
Oui, merci, monsieur le.
Thank you, Mr. Chair. I will start with some comments, first of all. I'm convinced, like I said this morning, that the press release from yesterday saying that the government recognizes that C-208, since royal sanction, is linked to the fact that there was a new meeting today, so I would like to congratulate everyone for their work. My question is the following, to come back to what I asked Mr. McGowan before. In yesterday's press release, the government says C-208 is now law. but there will be a new bill to amend C208. So we studied this for 127 days. So why is it that the government did not propose that in the normal process? 127 days is a lot of time. And like you said, it's not the first time that there's such a bill. Emmanuel Dubourg from the Liberal Party a few years ago had such a proposal. Guy Caron, Xavier Barcelot, and now Mr. Maguire. This time was the right time. There was royal sanction, but the government does not recognize the royal sanction in the power of the House. So now we're saying there will be a special committee meeting. The government says yes, but there will be amendments. My question is the following. Why is it that those amendments were not proposed during that process, during the 127 days? I asked the witnesses here, did the government ask you to prepare amendments? Because I remember Mr. McGowan came here and he said, oh, it's very complicated. There are a lot of problems. It should be solved. So I asked, did the department prepare, at the request of the government, amendments? Was it integrated in those 127 days? But now we hear, oh, this is secret. We can't answer this. So what I get from this is that if the government asked to prepare amendments, because now if they're not ready, they should be soon, because the government announced that there will be a bill with those amendments. So either the government did not do its work, which should have been to ask the department to prepare the amendments and propose them. We were working harmoniously here in committee and at the House. We could have worked together. I'm sure it would be a great cooperation. It would have worked. No, none of that happened. So what happened? Mr. Chair, I'm going to give you my hypothesis. I think the government was thinking about elections already last spring. So they said, it doesn't matter if you work on C208, it will die on the order paper anyway. We're going to have elections. And then, oh, there was a third wave. So they would lose face. And then there was royal sanction. Oh, well, there was a little problem in their game. They did not predict that, but they thought, oh, those days are not enough. We will recognize it, but there will be a new bill to do what we should have done in the past. This is really, they're amateurs. That's my comment, and I do not have questions now. Thank you.
Yes, you've used up all your time on your comment, if I might say so, Mr. St. Marie. Just so there's no confusion, the list is as follows. Ms. Matheson, then Mr. Maguire, Ms. Bendayan, Mr. Berthold, and Mr. Gerritsen. That's who I have on my list at the moment. So we'll go with you, Ms. Matheson. Same amount of time as Gabriel, so you'll have about 3.5 minutes.
Okay, thank you so much. If I may ask, what consultations have been done by the department on these not exact amendments, but again, as you indicated, general questions, amendments put forward in the press release that was released yesterday?
Well, the press release announced a set of issues that would be considered as part of the consultations, and announced an intention to release draft legislative proposals in the near term. I believe the language was that they would be forthcoming. So we put out the ideas under consideration in terms of how best to define a genuine intergenerational business transfer. Shortly, there would be a release of draft legislative proposals, which would, of course, as they would be legislative in nature, provide more specificity as to what those would look like. That release would be followed by another consultation period before ultimately final proposals are released. And so that would provide for a number of rounds of public consultation on the best way to define what a genuine intergenerational business transfer is, and that's coming out of yesterday's release.
Okay, so that was very, very general. So there isn't a specific deadline that you have. I mean, you certainly have the November deadline of being able to have this legislation passed, but you'll obviously have to do a lot of that consultation beforehand. How long typically would that level of consultation take, as far as you can estimate?
Well, as has been noted, there's an announcement to put out draft legislative proposals shortly, and then a commitment that whatever effective date those proposals could take, it would not be before November 1, 2021. It's difficult to provide a timeline in terms of putting together a set of draft legislative proposals of this complexity. I can speak to the general timeline for budget proposals if that would be a helpful comparator. Often in the federal budget, which is released in the spring, March, April, we will, or the department or the government will announce its proposed measures or income tax measures. It is common after the release of a budget announcement for there to be a summer release of draft legislative proposals in the summer. Those draft legislative proposals would go out for comment, often for a period of 60 days, before measures could be introduced into a fall budget bill. So while it's of course impossible to predict with any certainty the timeline for this measure, that's not uncommon timeline for at least some budget measures, if that would be a useful comparison.
Okay. And how would a potential election disrupt? Would you be able to continue those consultations throughout that time, or would it put a hold to everything?
That depends on the specific rules for government officials or civil servants to interact during part of the caretaker period after a writ has been dropped. Obviously, we would continue to analyze submissions, but I don't know if Miodrag or Jennifer know the specific rules for caretaker stakeholder engagements on consultations.
Anybody else want to come in there? Okay.
I don't have much to add to Mr. McGowan's statement here. I think that's it. I mean, as long as it's internal work and we could focus on analyzing submissions we may continue to get during that period. But then the question would be after that, if there's a need to reach out, then we would need to be mindful of the caretaker convention. Thanks.
Thank you. We'll go now to Mr. McGuire, who will be followed by Ms. Bendayan.
Thank you, Mr. Speaker, as well, or Mr. Chair. Sorry, Mr. Chair. Just want to go back to a question for clarity, even that one of my Liberal colleagues had asked earlier in this area to Mr. McGowan. You've said that the current plan and the message to the small business owners is that C208 will be in effect, unaltered until November 1st. But can you confirm that any small business transfers to family members that take place between today, or even June 30th, and November 1st, will not be subject to any retroactive application of any further amendments?
Yes, that was the government's announcement that whatever conditions would be introduced in a later bill, which again would have to go through Parliament, those restrictions or conditions would not apply before November 1st. So from now till October 31st, the law as enacted by C208 would apply at a minimum.
So I guess my question was to do with any amendments, but amendments, a new bill coming forward. We don't have one now because it's law. A new bill coming forward by the government. Could that be retroactive?
As we've discussed, these amendments to the Income Tax Act that were made by C208 are part of Canadian law and could only be changed through a subsequent bill tabled in Parliament that receives royal assent.
Be made retroactive
asked,
and in a new bill.
Well, the government has announced that it would not apply before November 1st, 2021. As a general rule, income tax amendments are often apply as of the date of their announcement. For example, see in Bill C-30, which received royal assent on the same day as Bill C-208. It was the first budget bill for 2021. That had a number of measures that had their application dates based on March 18th, 2019, the day of the 2019 federal budget. Those related to, for example, the foreign affiliate dumping rules, some mutual fund trust measures using an allocation redeemings methodology, individual pension plans, like several amendments had their application dates.
But the government is supposed to be putting the press release out yesterday, Mr. McGowan, to clarify. That was the title they put on it. Clarify the taxation for intergenerational transfers of small business shares. And yet we've got this confusion that there's a contradiction between, obviously, it tried to be a correction because they thought on June the 30th that they could go retroactive and make amendments to do it. Now they're saying they can't or won't. And I think there's a big difference between can't and won't. So if you bring in a new bill, obviously they could go back retroactively, even if the press releases aren't law. So I guess all I'm saying is, can we get clarification from you on that?
Jennifer, did you want to comment on the ability of Parliament to pass retroactive tax bills?
Ms. Aiken?
Point of order, Mr. Chair, is this a hypothetical question? Because we are asking officials to speak on behalf of what the government intention is with respect to the press release of yesterday indicating that we would introduce safeguard measures and amendments to the legislation. I clarified this morning that it is not the government's intention to put any legislation retroactively. I'm not sure why we're asking officials for something that they do not control.
Speaking to the point of order.
Mr. McGuire, first on this point of order.
I think therein lies the point of order. She said it's their intention, not that they won't. So, I mean, it's still ambiguous.
Mr. Kelly?
I think that this is really the same line of questioning in a way that that Ms. Zarowitz introduced earlier in her testimony, so I presume it's relevant.
I'll let you answer, Ms. Aiken, but I do think we need to come back to the minister's press release at some point and say what the intention of the government is by someone who can speak for the government. The minister was very clear, in my view, in terms of a press release. Ms. Aiken, do you want to answer that question?
Thank you, Mr. Chair. I would go back to the question of whether it's a hypothetical question of what type of legislation the government can, or a general question, I should say, about what type of legislation the government can introduce. So it is possible, and I think I heard the law clerk say it this morning, it's possible for legislation to be introduced that operates retroactively, and it has to be made very clear. On the question of what the government's intentions are, I don't have any knowledge beyond what's in the press release, but I think that expresses that clearly.
Mr. McGuire.
Thank you. I'm not sure that clarified it, but Mr. Chair, I'd like to ask if the people in the Department of Finance know whether the justice officials were consulted on the illegality of delaying the implementation of C-208. And I'm talking about the consulted, not the advice, because we went through that this morning.
Can anybody answer that question? I imagine it's a confidence of government, but go ahead.
Go ahead, Jennifer.
Go ahead. Whoever wants to take it, Mr. McGowan, Ms. Aiken.
I was just going to say that from the point of view of whether or not there were consultations with justice, that is a matter of solicitor-client privilege. So it's not something that we're at liberty to talk about. But we can talk about the press releases that are in front of everybody, and we can answer questions on those.
Okay, thank you. Last question, Larry, you're a little over time, but I took some time.
So I guess I'm just wondering, Mr. Chair, why did it take almost 20 days for Finance to provide an updated release here? Was it because we called the cabinet meeting? You so graciously called this committee meeting, not cabinet meeting, this committee meeting today? And was it, as was referred to earlier, a decision made by Executive Council or Cabinet, if not, like Mr. McGowan has already answered, that the Minister was in charge and made that decision? Was it, in fact, the Minister, or was it, in fact, Executive Council or Cabinet?
Can anybody take a stab at that? It's not going to be me. I tried once and got in trouble. Yeah, you did. Sorry, Ms. Aiken, or Mr. McGowan, or Mr. Jovanovich.
Thank you, Mr. Chair. I believe the first part of the question was why it took 20 days for the second news release to come out. I'm not sure I have an answer to that. All I can say again is throughout the process, as we do normally, we continue to brief the minister, and I cannot comment on specific aspect of the briefing, but we just continue to do so. And at some point, the decision was made and a news release was drafted, and that's basically the time it took to do so. On the second question, with respect to, again, who took the decision, I believe that, Mr. Chair, we answered that question before.
Okay, thank you. Before I turn to Ms. Bendayan, nobody's talked about the 4 points in the press release, and I think I can say this in all fairness. Nobody on this committee, or I think any parliamentarian, wants to see a law used for tax avoidance. So what in your points that you outline, or that the minister outlines in her press release, are they to target what they see as the dangers, I think it says in the press release, of surplus stripping? Is that what it's mainly targeted at, and not the genuine aspects of intergenerational transfers, which brings fairness and equity under the tax system, to selling intergenerationally versus outside the family?
Right. Thank you for the question. I think that the idea in the July 19th press release was to provide a set of 4 issues that would need to be considered in the course of developing a rule to help distinguish between genuine transfers of a business to the next generation and between more contrived tax planning that does not, in fact, result in the transfer of business to the next generation. And so the idea would be to develop a set of rules in order to help distinguish between the 2 cases, to help ensure that the benefits provided, which is to say, the non-application of the anti-avoidance rule in Section 84.1 of the Income Tax Act, is available to the to intergenerational transfers of a business, but only in the appropriate circumstances. So these 4 bulleted points are just the sort of things that would typically need to be considered. And of course, for a view of a fully fleshed out set of rules, Quebec has some, and they deal with a lot of the same points, although maybe not conceptually ordered in the same way. And one is the control of the company that carries on the business going to the next generation, whether or not the parent can retain ownership in the company after the transfer, and what type of ownership. be preferred shares, common shares, things like that. Whether there's a particular timeline involved for the transition of the involvement in the business between between the parent and the child, or whether it's just a more general requirement that the parent can stay on in order to transfer their knowledge to the child. And finally, the level of involvement in the child after the transfer of the business, whether or not they have to maintain an economic interest through shareholder ownership for a particular period, or whether they need to be actively involved in the carrying on of the business itself. So these are all issues that need to be considered and developed in the course of developing a rule that appropriately targets real intergenerational transfers.
Okay. Ms. Bendayan.
Thank you, Mr. Chairman. And actually, I will pick up on the point that you just raised with Mr. McGowan. Certainly, as Parliamentary Secretary for the Minister of Small Business, I've been working very closely with entrepreneurs over the last 2 years now. And it is my impression, and I hope yours as well, Mr. McGowan, that our entrepreneurs here in Canada are extremely hardworking, that they are working double time in order to keep their head above water and are intent on growing their business and also intent on following the rules. I do appreciate, though, as a lawyer, that our tax legislation, does need to be reviewed every once in a while and ensure that we have the necessary safeguard measures in place so that, very experienced tax lawyers are not finding loopholes. But there are very few bad actors, I hope you'll agree with me, among our small business community. And I thought it would be important for me to clarify once again that the small business community would not only be consulted, as you were discussing earlier, Mr. McGowan, but that the government would not be applying any changes to tax legislation retroactively. You mentioned a number of times the date of November 1st as being the earliest date on which changes might be introduced. But I would also like you to clarify that it's not actually between now and the end of October, as you mentioned, but really November 1st is the earliest possible date. But as the press release states, it could also be up until the date of publication of the final draft legislation, which could in fact be later. Is that your understanding?
Yes, it is the later of November 1st and the final publication of draft legislative proposals. So the earliest it could be is November 1st, but of course it could be later than that.
And of course, as you mentioned, but bears repeating, that would be subject to parliamentary approval. We would have to pass this legislation in the House of Commons, and that is dependent, again, on parliamentary supremacy.
Yes, that's absolutely correct. It would need to be tabled as part of a bill and then pass through Parliament and receive royal assent.
And once again, it may seem obvious, but I would like to confirm that our small business community won't be taken by surprise by anything that the government may introduce, because they will be intimately involved in this consultation process, which you mentioned a few moments ago.
That is certainly the intent behind yesterday's release, I think. Yesterday's release provides a bit of a framework for the development of issues, and that will provide a general idea until draft legislative proposals are released in the near term. So we've already started hearing comments on the conditions in yesterday's release. So that dialogue will continue through to when draft legislation is released. There will be another round of consultation on the draft legislative proposals, and then the measure itself will not apply before November 1st, and then ultimately, as said in the press release, there's an intention to release final draft legislative proposals afterwards. So there are a number of steps in the consultative process where stakeholders would be engaged.
Thank you, Mr. McGowan. And not to further belabor the point that Mr. Fragos very eloquently stated earlier, but the issue, I think, has been clarified. We now understand that these amendments to tax legislation for intergenerational transfers came into force on June 30th. But I thought I heard you say earlier in your testimony that some tax changes often come into effect in a new tax year. Obviously, that is not the case, again, to be perfectly clear, with the changes that we're discussing here in committee today. But could you elaborate a little bit more on how CRA perhaps needs to work in the background in order, to prepare for these modifications to tax legislation, and why it is that in some cases, not this one, but in some cases, the application date would be in a new fiscal year?
Thank you for the question. It's important to note, I think, that as I believe I may have mentioned earlier, in terms of these amendments, they would be reflected in an individual's tax return that gets filed for the 2021 taxation year. And so there's no administrative action that I think the CRA really needs to take until it starts looking at those tax returns well into 2022. And so there's a little bit more time for the CRA than having to administer or assess right away, and it's important to keep that in mind. Now, it's often the case that amendments might apply for, as of a particular date or to a taxation year. Amendments that apply to as of a particular date are typically transactional in nature. So, they might apply where you sell shares or pay a dividend or make a particular type of investment where you can you can pinpoint with specificity when that transaction occurred and what day it occurred on. And so that's typically something that we would look to in developing measures and making recommendations for their effective date. For rules where that affects the computation of income over a period or over a taxation year, where they can't be tied down to a specific transaction that occurs on a specific date, rather they apply throughout the taxation year, then I would suggest that application dates that apply as of a particular taxation year make a lot more sense. So it really depends on the measure, and providing the application date that works best and gives the most certainty for affected taxpayers.
Okay, we will have to end it there and go to Mr. Berthold, followed by Mr. Gerritsen, and then anybody else who wants in will go there, but I'll need a list. I see Mr. Fast wants in after that. Mr. Berthold.
Merci beaucoup, Monsieur le Président. Monsieur le Président, je vais demander...
Thank you very much, Chair. Mr. Chair, I'm going to ask for your indulgence. I know that some of the questions I'm asking seem redundant, but I believe it's important to ask them in French as well of our officials. So I may re-ask some questions that have already been asked. But first of all, I remind you that we're here not because of the press release that was... We're not here because of a press release that was put out yesterday, but the one that would come out on June 30th, 2021, that said that Bill C-208 was there to amend the Income Tax Act, but did not have an implementation date, which also shocked you, Mr. Chair. The government is proposing that this bill be implemented only as of the next fiscal year, January 1st, 2022. That's why this committee was called. It's because of that press release that we are here today. And yesterday, the government realized that the committee was meeting today, and they might look a little crazy. And they decided to change the tax and to issue a new press release in order to deny what was said in the first press release. Unfortunately, you can't erase press releases, Mr. Chair. The June 30th press release exists. I saw it, you saw it, many people saw it, many small businesses saw it. All kinds of people in the agricultural sector saw it, were offended and shocked to see that the government did not want to implement a bill that was adopted by both chambers that had received royal assent. Unfortunately, it seems that because this is a bill that this time was tabled by a Conservative, the government decided on June 30th, oh, we can't adopt that. No, that's dangerous. We can't give any credit to the opposition parties. However, Mr. Chair, unfortunately, it is a fact. It was adopted. Luckily, we found that now the bill is going to apply. What we'd like to know, what we need to know, what happened on June 30th that brought us here to gather right in the middle of the summer, right in the middle of our construction holiday, to talk about what this bill was going to do to and what effect it was going to have for small businesses and small farmers and others. Mr. McGowan, you said earlier, and I quote you in English.
Decision. Monsieur McGowan.
Mr. McGowan, can you please tell us the name of the minister who made that decision? The decision that you were talking about?
And I know we've been over this before, but it is Mr. Berthold's right to ask the same question again, so I guess it's your right to give the same answer.
I believe our answer to this question would be the same, Mr. Chair. Notre réponse est...
Our answer is the same. In that case, Mr. Jovanovic, could you please confirm that what Mr. McGowan said earlier, the minister made her decision?
The
statement that was issued on June 30th emanated from a government. In fact, it was in fact a government announcement, the announcement by the government of Canada, which was proposing at that time that legislative changes be introduced in Parliament. Mr. Chair, my question was clear. Earlier, Mr. McGowan said the minister made her decision. Mr. Jovanovic, can you confirm for me that that is what your colleague said? The Department of Finance could not have issued a decision without the approval of the government. So it was a government decision. Question. And why, Mr. Jovanovic, can you not name, tell us which law or circumstance prevents you from naming the minister mentioned by your own colleague just a little while ago to approve that press release. I have been Chief of Staff, Mr. Jonich. I know that there is no press release of that scope or importance would have gone out without the highest level of approvals in government and at cabinet. So why are you so reticent simply to confirm that the Minister of Finance authorized this press release, this June 30th press release? That is why we are here today. Mr. Chair, if you'll allow, it seems that I'm trying to be made to say certain things, but I'm just trying to tell you that there is a decision-making process for any government decision. It's not our place to say which government member made the decision on an individual basis. This is a government-based decision. We work for the government. We provide the Minister of Finance with advice, which is probably why Mr. McGowan answered that. But nonetheless, the fact remains that this is a government decision. It is not our place, and it's probably not necessarily the information that we have. We do not necessarily participate in political discussions. I understand.
Considerably over time, and I'll go to Mr. Gerritsen, but I do remind the committee that the government also made a decision on July 19th, and that's another press release. And government, go ahead, Mr. Gerritsen.
Thank you, Mr. Chair. Mr. McGowan, my questions, I guess, would be for you. I just want to start a little higher level for a second. So basically, you know, the job of the Finance Department is to implement the Income Tax Act as it happens to be at that particular time, correct?
No, actually, the administration of the Income Tax Act is the responsibility of the Canada Revenue Agency.
Fair enough.
The Department of...
Fair enough. But in terms of any changes that might happen to that act, no implementation of those would occur before any such time that they would come into effect, correct? So if a law is passed that changes, as is the case with this one, there would be no work that would be done on that prior to that taking place, correct?
I'm not certain that I understand the question.
So the Income Tax Act as it currently stands is in its current form is implemented in that way. The rules are followed. Until such time that that is amended, there wouldn't be, you wouldn't start looking at following, you wouldn't start new laws that could potentially be coming down the pipe, correct? The reason why I ask, it's a very straightforward question. I think the answer is yes. It's supposed to be a rhetorical question. The reason why I ask is because Monsieur Saint-Marie and others have been asking the question of, well, why didn't you prepare in advance for the inevitable that you saw coming? And quite frankly, your job is to implement what is before you, correct?
Okay, so I thought the question related to measures that have received royal assent in the Income Tax Act, but that do not have effect until a delayed date. And there are certainly provisions in the Income Tax Act that do not yet apply to certain taxpayers.
Sure.
For example,
so when you're asked when you're asked the question by Monsieur Saint-Marie, for example, where he says, "Well, you knew this was going to happen. It was coming down. It had been passed by the House. It was on its way to the Senate." As far as you were concerned, on June the 28th, the bill had not received royal assent, and therefore was not something that you needed to start dealing with. Is that correct? Or am I wrong? Do you actually start to work on that stuff before it becomes law?
We, as department officials, as my colleague Mia Drag has noted, we continually work on providing the best and most frank advice we can to the government, and that relates to the
Mr. McGowan, I'm not
bills.
talking about advice. I'm not talking about advice. I'm talking about what the law is. You're going to implement the law that is currently in place. So on June the 29th, when a new law comes into place, if you're not ready to start implementing that because it's brand new to you, you might not have the tools and resources that you need to do it immediately. Educating and informing those that are implementing it, making sure that the system is being treated equal. People are being treated equally. Making sure that that tax avoidance isn't occurring where it shouldn't be. Like, those are all things you need to consider, right, in implementing this legislation. But if you were unaware that it was going to become law on June the 28th, and presumably you didn't because you didn't know how the Senate would vote on it, then you wouldn't be able to actually properly plan for it on that date, right?
Okay, thank you. I think I understand the question now. I had been focusing on
if you could just answer
when
my question.
the date on which it received royal assent and amended the Income Tax Act, but in terms of the administration of the rules in Bill C-208 and whether or not the Canada Revenue Agency was ready to go on June 28th for that, as they are the administrators of the Income Tax Act. I think that would be a question better put to them. Certainly they monitor developments, but it's the CRA really who is tasked with administration and enforcement of the provisions of the Act.
I know. And so just for clarification, has there ever been a situation before with a private member's bill that you're aware of that has come into effect, and then the intent was to immediately change the tax, the way that the Income Tax Act was the way that it was enforced, effective immediately? I'm trying to understand why the need was for putting this buffer of time between when the law became law, as passed by the Senate and received royal assent, to when the projected future date would have to be.
I'm not aware of a private member's bill that has received royal assent and then shortly thereafter private member bills amending the Tax Act and receiving royal assent are not terribly common. And this is the first one that I can think of that has amended the Income Tax Act. My colleague, Mia Drag, I think, might have a better recollection of one that slightly different facts, but a government bill was passed which provided that
Perfect.
A
Thank
private
you.
member's bill would not come into force, but that's a slightly
Thank you.
different situation.
That's all I need. Thanks.
Nobody else wants to further answer that question. Now we know that Larry Maguire has done a rare thing, that's for sure. We'll go to Mr. Fast, and then a split time between Ms. Zerowitz and Ms. Bendayan, and then Mr. Kelly. Mr. Fast.
Well, Mr. McGowan, I've got a couple more questions for you, and let me say again that I do have great respect for those of you who serve the public in your position. I've been in that seat, been asked questions like you are. It's not a pleasant feeling at times, especially when the great inquisitor is Mr. Easter, who used to do that to me. But that said, you have said that it's the intention of the elected government that any intergenerational transfers that take place between June 30th and November 1st will not be subject to any further amendments that the elected government might bring forward on November 1st with respect to such transfers. Now, Ms. Aitken has, however, confirmed that the government can, in fact, make such legislation, the November 1st legislation that is signaled in the press release of July 19th, that the government could make such legislation retroactive. So I'm assuming that you yourself cannot bind the government to compel it to follow through on its intention not to apply any further amendments to such intergenerational transfers. Am I correct?
I would say that the government, an elected government, can't make changes. Of course, any change would have to be included in a bill, and only Parliament could enact that to change the existing law. So I don't know that it is something the government could do, absent going to Parliament through the legislative process to make changes to the Income Tax Act.
Well, let me dig it a little deeper. You've mentioned that surplus stripping is a significant concern and that needs to be addressed in the amendments that the government intends to bring forward. If between now and November 1st, such tax avoidance activity does in fact take place, how will the government effectively address that avoidance?
Well, the government in its July 19th news release said that it would be releasing conditions that would need or conditions for defining what is a genuine transfer, and that would entitle a transferor to make use of the exception for the anti-avoidance rule in 84.1. So it said that it would allow the benefit, or that it would provide conditions that would need to be met in order to be considered to be a genuine intergenerational transfer that would apply no earlier than November 1st, 2021. So right now, the law as enacted by C-208 stands, and those conditions would not be implemented until after October, at the earliest.
So there's a gap now, right, between June 29th and November 1st, in which the government does not intend to make any retroactive changes, in which there may be some gaps or some loopholes that you've identified that may be difficult to address. Is that correct?
My only hesitation is that not before November 1st, so up until October 31st, then the government wouldn't introduce other additional conditions in excess of what's currently there now. So
okay,
that's right. The law that's in place now will be there until October 31st, or until November 1st at the
all right.
At the earliest.
My last question. The most recent press release, which is the July 19th one, in which the elected government did an about-face on Bill C-208. Certainly we see it as an about-face. It still suggests that some intergenerational small business transfers aren't genuine. In fact, you use the term genuine in that press release. I'm looking at it here. It still suggests that small businesses are engaged in tax avoidance in surplus stripping, in artificial tax planning, and in not paying their fair share. So do you understand why many small businesses and the families that run them still feel that you and your finance department colleagues and the government and the Prime Minister still believe that they're tax cheats? I mean, it's baked into your press release, and small businesses reading that would take from it, well, you know, this government really doesn't trust us small businesses. I think they still believe we're tax cheats. You understand why small businesses are concerned?
Thank you for mentioning that, and it brings me to something that I wanted to mention earlier, where I forget the question, but there was a suggestion that somehow tax planning using the law of the day could be considered bad behavior, or something like that. And of course, if there are gaps in the law, that is a problem with the law, and not a problem with people who arrange their affairs in such a way as to to reduce their tax liability.
Then we will go to Ms. Zerowitz first, and then Ms. Bendayan on a split. If you want to go with the split.
Thank you so much, Mr. Chair, and thank you, Mr. McGowan, for your patience in answering all these questions. I'm just going to continue a little bit, just because Mr. Fast must have been reading my mind. He asked a couple of my questions. I was going to ask a similar question in terms of between June 29th and November 1st, as sales are, you know, whether it's family farms or other types of small businesses that are intergenerational are taking place. I know you had indicated there's no plans for any amendments, but is there anything that you think the federal government could do or should do to minimize any tax avoidance in the meantime?
Thank you for the question. As I've said before, both today and before, certainly the Senate Agriculture and Forestry Committee in an earlier appearance on Bill C-208. Right now, the tax administrators, the Canada Revenue Agency, they're tasked with applying the law as it stands and not anything else. And so the CRA, I'm sure I can say with utmost confidence, will apply the law as it currently exists, as is their mandate. So I would never want to suggest that anybody could do anything other than apply the law as it currently stands.
Yes, I guess just a tiny follow-up, and then I'm going to pass along to my colleague. But if we have been concerned, which is something you had raised at our Finance Committee meetings while we were studying this bill, of the possibility of people taking advantage of what you see as potential tax loopholes in the way that the current law is written, why wouldn't we try to take some steps to minimize that while ensuring, in the meantime, or look at, not make amendments, but maybe take some measures or considerations?
As I said, the Canada Revenue Agency would, the government would apply the law as it exists. If planning develops that kind of goes beyond what the legislation currently permits, or including if it somehow crosses the level to becoming abusive tax avoidance, of course that's something the CRA would look at. But again, just to reiterate, the tax authorities are bound to apply the law as it exists.
So much.
Bendayan.
Thank you very much, Mr. Chair, and thank you to my colleague for giving me the time. I am outraged. I know that people who know me know that I hide my outrage quite well, but Mr. Fast feigned to speak on behalf of small business owners and entrepreneurs here in Canada, indicating that or claiming that our government is accusing them of X, Y, or Z, when in fact I believe that entrepreneurs know and understand that our government has always believed in them, continues to believe in them, and has been supporting them really from day one of this pandemic, but well before and well into the future. And I do believe that Mr. Dan Kelly from CFIB does represent small businesses, and he tweeted his thanks earlier today to Minister Freeland. I have the tweet in front of me in which he says that both the minister and her officials are to be thanked for the clear message that this new law will be respected by the Department of Finance and CRA. And as I shared with the Deputy Prime Minister, CFIB will work closely with the government to protect the integrity of the tax system by closing any gaps that may be identified. So even Mr. Kelly is looking forward to working with our government in order to implement safeguard measures and work with us to close any loopholes. And Mr. McGowan, I think you indicated earlier that you are also looking forward to working with stakeholders such as Mr. Kelly at CFIB and others. Is that correct?
Yes, of course, very much so. We put out a release and we'll put out draft legislative proposals for consultation, and we expect really good stakeholder engagement.
Thank you very much, and thank you, Mr. Chair.
Okay, thank you, and we're going to Mr. McGuire, I understand now, rather than Mr. Kelly. Mr. McGuire.
Okay, thank you, Mr. Chair. I just wanted to, regards to Ms. Bendayan's comment there, I just have to add the reason that Mr. Kelly was able to put those kind comments out is because the government was forced to appear before a committee today. I want to thank you, Mr. Chair, for calling this meeting, because without it, this wouldn't have happened. Like yesterday's press release just wouldn't have happened. There's no news hiding the fact that the government is recused on their decision from June the 30th to yesterday's press release. So Mr. Kelly is quite right to say that they're pleased, but the government has, and I wanted to go back to my friend Mr. St. Marie, because he was saying 127 days. He was right earlier this day when it was 527 days, and that the government fought this bill and fought it hard, not only in their own. And if it was such a good bill, why didn't they vote for it in the House? 19 of your colleagues, Mr. Chair, you included, got the fact that small business in your constituencies, in every constituency in Canada, is it is the predominant private sector employer in those constituencies. And so I just want to reiterate that without the attention brought to this bill, the government has fought this all the way until yesterday, and they decided, well, this isn't very popular amongst small business people in Canada, and we better change our minds on this. So I just want to there's a couple of quick questions, Mr. Chair, and I know we still have a bit of time, but I want to ask Mr. McGowan, before yesterday's press release was issued, which stated the obvious that the law is the law, were you consulted on the language in the updated release?
Do you mean were Department of Finance officials involved in the production of the July 19th release? The answer is yes, we were involved in that.
So it goes without saying that if we didn't put up this fuss, the finance wouldn't have sent out the updated press release. So what specific day were you told a new policy decision was going to be taken?
I don't know about timelines. Miodrag, do you know?
It's very difficult to say. I mean, it's an ongoing and iterative process that the Department of Finance has with the Minister's Office and the Minister in terms of briefing 30th. And reacting to events. So
I say obviously it wasn't before June 30th. Would that be obvious? Yes or no?
You mean with respect to the decision to issue the July 19th
to what specific
news
day were you told a new policy decision was going to be taken?
I can't answer. I actually...
You don't know?
I don't know.
You just,
as I said,
Mr. McGowan just said that you were informed. So anyway,
go ahead.
Obviously,
go ahead, Larry.
So, having said that, obviously you were informed by the government that something was going to take place, that this reversal was going to take place. So did Cabinet have to approve this new policy direction, or could it solely be made by the Minister of Finance?
Well, I would say that these decisions, they're made by the government and implicitly the cabinet. The cabinet, with respect to tax-related matter, can be the prime minister with the minister of finance, or along with other ministers, depending on potentially the nature of the issue. But I mean, it's a decision that is taken in concert by the government.
You know, I understand that the government doesn't like Bill C-208, but not a single amendment was put forward, by them through this whole process, and now we still don't have amendments. They're talking about them here, but why don't we see that if there's amendments there, why aren't we seeing them now so we can discuss them before even a committee like today? Have you been asked to put forward amendments?
Well, the government announced
It's had 20 years.
The government announced its intention to release, saying that amendments to the Income Tax Act relating to intergenerational transfers would be forthcoming. In its July 19th press release, the government did announce an intention to release draft legislative proposals on the subject.
Specific legal authority did finance use to release and announce this tax policy change?
I'm sorry, I'm not certain that
I'm just asking what specific legal authority did finance use to issue the release and announce this tax policy change in a press release?
Jennifer, I see you've gone off mute.
So,
You're on
Mr.
here.
Chair,
Go ahead.
I can try.
Yeah, go ahead.
I'll try to answer that in terms of legal authority. It's a news release from the government, as my colleagues have said. It was a government decision to issue a new news release, but a change to the law requires Parliament's approval, and that's why, in fact, both news releases speak of an intention to introduce legislation, which would go to Parliament, which would go through the whole process in the House and the Senate, and would only be law. So there would only be a change in law once there was royal assent. So the legal authority to change the law comes from Parliament, and that's what's referred to in the news release.
So clearly there's no amendments forward to clarify for small businesses in Canada what the government's intentions still are.
The government has said in its news release what its intentions are, but those intentions are to introduce proposed legislative amendments, which can't become law until Parliament decides.
But there's nothing from stopping them from discussing those amendments today, because we've had decades of discussion on this particular topic, and it leads those in small business today to really go back to my colleague Mr. Fast's comments. He called it the tax cheat issues. I'll be clear that the Prime Minister, his very words were something to the effect that small businesses are just formed to allow for tax avoidance. And I think that's a pretty clear message from the top leadership of the country as to what they think of small businesses. And to come out in the release and say that, oh, we're one of the most friendly governments ever to be in place of small businesses. I've had chartered accountant firms tell me that this bill is probably the most significant change that would help small businesses in the last 20 years. So, there's a great dichotomy of opinion here, Mr. Chair, and I ask, why we still can't see some of the amendments, or why we're not here today discussing some of the amendments that have been obviously talked about, because the department put forward its case before the House, before the Senate, and both houses, both departments of the parliamentary process passed this bill. So I leave it at that, Mr. Chair. I don't know if there's an answer from the government as to why we're not seeing amendments today, or from the Finance Department, other than maybe the simple question. Has the government instructed the Finance Department to come up with any amendments yet?
Look, well, I'll go to
my final question.
I'll go to okay. I guess that was a question to you folks. Has the government instructed the Finance Department to come up with amendments? And I refer you to the press release in that matter. Mr. Gowan or Ms. Aiken or whoever.
I mean, the press release states that amendments are forthcoming. So, I mean, that is something that that we're working on in consistent with the announcement of the government of Canada that the amendments are forthcoming, and so
based on the consultations, if I could, is that correct, Trevor?
We're certainly working on putting together amendments. Again, these are the ones that are announced in the July 29th. And of course, in doing so, I don't want to suggest that we've launched a formal consultation process that would need to end before the draft legislative proposals are released, but certainly we've heard already from stakeholders with suggestions on ways that the bulleted issues could be addressed.
Okay, thank you. And I think you said July 29th, but you meant July 19th, if I'm correct. This press release is July 19th. Okay,
apologies, another slip of the tongue.
That's fine, Trevor. But I would say, just Mr. Maguire, you said the government doesn't like C208. The minister made clear the government of Canada is committed to facilitating genuine internet generational shared transfers, and they did raise some concerns with CO28. So let's be absolutely clear on what's happening here. Ms. Bendayan, and then Mr. Kelly will close it off.
Thank you, Mr. Chair, and I must say that I'm very pleased to see Mr. Maguire here. He certainly deserves the credit for bringing forward Bill C-208, but as other members have also said, Monsieur Emmanuel Dubourg from the Liberal caucus has also brought forward something very similar as the Bloc and the NDP have done over the course of the last many years. Mr. Maguire, you also mentioned that this issue has been discussed and debated for the last 20 years, 10 of which there was a Conservative majority in which the Conservative government of the day could have brought forward these measures. But je pense que
I think I'll have a few questions for Mr. McGowan now, because since this morning, in fact, people have been referring to Quebec and to the integrity measures in place in my province in Quebec. So I'm wondering if you were inspired by anything in particular, and whether there are any Quebec-based measures that we could implement on our end here throughout the country. Can you elaborate on that?
Certainly, we've gone through the Quebec intergenerational business transfer rules, and they provided a great source of inspiration for the work we're currently doing on them, and I think some of that is probably reflected in the bullets in the July 19th press release. So it is certainly a made in Canada set of rules to deal with same or similar issues that we're talking about right now. So it's absolutely been an important source of inspiration. I mean, we've heard about technical questions from relating to the Quebec rules and the impact of Bill C-208, but I'm not a Quebec expert on their provincial tax, so I can't really comment on that sort of thing.
Merci, Monsieur McGowan.
Thank you, Mr. McGowan. It's always a pleasure for me as a proud Quebecer to see to what extent Quebec really inspires the rest of the country, especially when you think of, the daycare system, and now you're raising the issues about the integrity measures. I think I'll be sharing my time with my colleague, Ms. Zerowitz. Julie, go ahead.
Final question.
Thank you. I just wanted to continue with my colleague's comment about we very much care about the intergenerational issue. And just want to put two things on the record and then ask my question. The first is, in the 2019 budget, we did say the government understands the importance of Canadian farmers, fishers, and other business owners' place on being able to pass their business on to their children. The government will continue to outreach to farmers, fishers, and other business owners throughout 2019 to develop new proposals to better accommodate intergenerational transfers of businesses while protecting integrity and fairness of the tax system. And then also in the December 13, 2019 mandate letter of the finance minister, it listed as a top priority to work with the Minister of Agriculture and Agri-Food on tax measures to facilitate the intergenerational transfer of farms. So huge issue for us. It has been an issue for us. It continues to be an issue for us. My question is, and this is just, I think, something you had mentioned, Mr. McGowan, how you said that there's a number of amendments that are being looked at. I very much took to heart the presentations that we had this morning, where we directly had representatives from the Canadian Federation of Agriculture, the Fédération de la Relève Agricole du Québec aussi, and they very much asked for, as we're making some of those amendments, direct involvement in consultation with the grassroots. So not just within the farming sector. I think that our chair sort of expanded that there are other stakeholder key groups that would want to provide input. The very clear message we heard this morning was that it is not a one-size-fits-all in terms of addressing the tax loophole solutions. And so I would like to inquire as to whether or not there's going to be some direct connections with these key stakeholders on the amendments that are being proposed.
I don't. Oh, Mio, it seems you want to answer. Okay, I don't. Just to say that I don't know that we can comment on the government's communication strategy beyond what was put out in the July 19th news release. So I don't know that we have any details to share on that right now. I don't know if Mio, you had anything to add.
I would just add that any stakeholder can decide to approach the Department of Finance, and we would be very happy to sit with them and hear what they have to tell us. We don't need a formal consultation process to do that. We do that all the time. We never say no to meeting with stakeholders. I would just add that they may have a more informed discussion will obviously be coming once the draft legislative proposals will be out for consultation for sure. But that doesn't prevent stakeholders from getting in touch with the department.
Okay, thank you all. And the last section goes to Mr. Kelly. Mr. Kelly.
Thank you. And I don't have a question. I know we're just down to the last few minutes, but I move that the committee invite the Minister of Finance to appear within 2 weeks of passing this motion.
It is an allowable motion, so it's on the floor. Any discussion? I don't see any discussion. All those all those in favor? Opposed? Carried. All right, the request will go to the minister. Then with that, look, I want to certainly on behalf of committee thank officials from finance and from justice for appearing before the committee today. And it is, as we know, sometimes difficult to sort out where you guys are at from the political side of the coin. And we appreciate your efforts in terms of appearing before the committee today, but very much appreciate your efforts. And I think that was said by members earlier from probably all parties during the last year as we went through this pandemic, and your advice to government, and you're working day and night to assist Canadians in getting us through the pandemic and trying to leave us in a position where the economy can go forward. So I want to sincerely, on behalf of the committee, thank you for your efforts there and for your appearance today. So with that, a meeting is adjourned.